The letter arrived on a Friday afternoon in late October. Standard company letterhead, professional formatting, addressed to me at my home. I'd retired 6 months earlier after 32 years with Meridian Financial Services, and most company mail these days was routine. Benefits updates, policy changes, that sort of thing. This letter wasn't routine. Dear Mr. Granger, due to recent actuarial reviews and plan restructuring, your monthly pension benefit will be adjusted effective January 1st. Your new monthly benefit will be $3,847, reduced from your current $6,215. This adjustment reflects updated calculations based on plan amendments approved by the Board of Directors. If you have questions, please contact the Benefits Department. I read it 3 times. They were cutting my pension by 38%. Wad. Nearly $2,400 per month. Almost $29,000 annually. With no explanation beyond plan amendments and updated calculations. I'd worked at Meridian for 32 years. I'd been promised a specific pension benefit when I retired. A benefit that was part of my compensation package, part of what I'd worked for, part of why I'd stayed with the company instead of pursuing other opportunities. The pension calculation had been clearly spelled out in the plan documents. 2% of final average salary multiplied by years of service. With my final salary in 32 years, that formula produced $6,215 per month. That's what I'd been receiving since my retirement. That's what I'd planned my retirement budget around. And now they were cutting it by 38%. With 2 months' notice. I called my wife, Margaret, who was at her book club. Marg, we have a problem. Meridian just sent a letter saying they're cutting my pension by almost $2,400 a month. What? Can they do that? I don't know. But they're claiming they can. What are you going to do? Call them Monday. And probably call a lawyer. That weekend, I pulled out all my retirement paperwork. The pension plan documents I'd received when I retired. The retirement calculation sheets, showing how my benefit was determined. The summary plan description that outlined the pension formula. Everything confirmed what I remembered. 2%, while final average. Salary cho years of service $215 per month. There was nothing in any of the documents about the company being able to reduce pension benefits after retirement. Nothing about plan amendments that could retroactively change what retirees were owed. Monday morning I called the benefits department. After 20 minutes on hold, I reached a benefits specialist named Karen. Mr. Granger, yes, I see the letter was sent to you about the pension adjustment. It's not an adjustment, it's a cut. A 38% reduction with no explanation. How is this legal? The company has made changes to the pension plan to ensure long-term sustainability. The new calculations reflect those changes. But I'm already retired. My pension benefit was set when I left. You can't just change it retroactively. The plan documents allow for amendments as approved by the board. Do those amendments allow you to reduce benefits that have already been earned and are already being paid? I'm not qualified to answer specific legal questions. If you have concerns about the legality of the changes, you should consult an attorney. Karen and I worked for this company for 32 years. I retired 6 months ago with a clear understanding of what my pension would be. Now you're cutting it by almost $30,000 a year. That's not a minor adjustment. That's taking away benefits I earned over 3 decades. I understand your frustration, Mr. Granger. But the decision has been made by senior management and the board. The adjustment will take effect January 1st, as stated in the letter. After hanging up, I sat at my kitchen table feeling a mix of anger and anxiety. Anger at the company for doing this. Anxiety about what it meant for my retirement finances. Margaret and I had budgeted carefully around my pension income. A $2,400 monthly reduction would require significant lifestyle changes. But I also felt something else, suspicion. Why would a major financial services company suddenly cut retiree pensions? Pension obligations are legal commitments. You can't just change them because you feel like it, unless you think you can get away with it. I called 3 attorneys that Monday, employment lawyers who'd handled pension disputes. The first 2 said they didn't take cases against companies as large as Meridian. The third, a woman named Patricia Moreno, agreed to meet with me. Tuesday afternoon, I drove to Patricia's office in downtown Portland. She was in her 50s, professional but approachable, with an office that suggested she'd been practicing employment law for a long time. I showed her the letter, the pension documents, the calculation sheet. She read through everything carefully, then looked up. "Mr. Granger, this is illegal. They can't reduce benefits you've already earned under a defined benefit pension plan. ERISA, the Employee Retirement Income Security Act, specifically prohibits it. The benefits specialist told me the plan documents allow for amendments. Plan amendments can change future benefit accruals. They can't take away benefits already earned. You earned your pension over 32 years of service. You retired with a specific benefit amount. They can't reduce it after the fact. So what do I do? First, I'm going to send a letter to Meridian's benefits department and legal team, informing them that you're represented by counsel and that the proposed pension reduction violates ERISA. That letter will demand they reverse the reduction and confirm your benefits will continue at the correct level. Second, we're going to request all documents related to the pension plan amendments, board minutes, actuarial reports, any analysis used to justify the reduction. What if they don't reverse it? Then we file a lawsuit under ERISA for breach of fiduciary duty and benefits denial. But most companies back down once they realize a retiree knows the law and has legal representation. Meridian is a financial services company. They have lawyers who understand ERISA. Once they realize you're not going to accept this quietly, they'll reconsider. Before I tell you what happened next, I need you to understand something about this moment. This wasn't about a minor benefit change or a policy update. This was about a company trying to take back earned retirement benefits from someone who'd given them 3 decades of service, hoping he wouldn't know his rights or wouldn't fight back. If you've ever had a company try to reduce your pension or retirement benefits, if you've ever been told that benefits you earned are being adjusted retroactively, if you've ever felt powerless against corporate decisions that affect your financial security, stay with me. Because what Meridian didn't know was that I'd kept every email, every document, every piece of communication from my entire career. And some of those documents were about to become very important. My name is Thomas Granger, and I'd worked at Meridian Financial Services for 32 years, from 1988 to 2020. I'd started as a junior analyst, worked my way up to senior portfolio manager, and retired at 64 with the pension I'd been promised throughout my career. Meridian was a mid-sized investment management firm, about 600 employees, managing approximately $15 billion in assets. Good company historically, solid reputation, treated employees reasonably. Well, the pension plan had been one of their selling points when recruiting. Good benefits, secure retirement, take care of employees who stay long-term. But things had changed over the past few years. New leadership, pressure to cut costs, focus on shareholder returns over employee welfare. 3 years before my retirement, Meridian had been acquired by a private equity firm. The acquiring company had immediately started looking for ways to reduce expenses. I'd been concerned about the pension plan even before I retired. There were rumors that new management wanted to freeze it or convert it to a cash balance plan. But I'd been assured by HR that vested benefits were protected, and that anyone who'd already retired would continue receiving their promised benefits. Apparently, those assurances weren't worth much. Patricia's letter to Meridian went out Wednesday morning. It was professionally worded but direct. I was represented by counsel. The proposed pension reduction violated ERISA's anti-cutback provisions. Any reduction would result in immediate legal action, and we were demanding documentation of the plan amendments and the analysis used to justify the changes. The response came Friday afternoon. Not from the benefits department, but from Meridian's general counsel, Robert Hutchins. Ms. Moreno, we received your letter regarding Thomas Granger's pension benefit. The company stands by its plan amendments and the recalculation of benefits. The amendments were properly approved by the board of directors and are in compliance with applicable law. Mr. Granger's benefit adjustment reflects accurate calculations under the amended plan provisions. Patricia forwarded it to me with a note. Standard stonewalling. They're hoping you'll give up. We're not giving up. I'm filing a lawsuit next week unless they produce the documentation we requested and reverse the reduction. That weekend, something occurred to me. When I'd retired 6 months ago, there had been discussions about the pension calculation. Ayer had sent me multiple emails explaining how the benefit was calculated, confirming the formula, answering my questions about what I'd receive. I'd saved all those emails. Not because I expected to need them for legal purposes, but because I'm methodical about documentation. I'd kept every significant email from my entire career at Meridian, organized by year and topic, backed up in multiple locations. I pulled up my archive and searched for pension calculation. Found 11 emails from my last few months of employment, all discussing my retirement benefit and how it was determined. One email in particular stood out. From Susan Chen, the HR Benefits Director, sent in March 2020, 3 months before my retirement. Tom, confirming your pension benefit calculation as we discussed. Using the defined benefit formula of 2% Hawaii final average salary, $96,867, Yocho years of service, 32 Kishi, $6,215.39 monthly benefit. This benefit is guaranteed under the plan provisions and will continue for life with survivor benefits to Margaret, per your election. Let me know if you have any questions. Guaranteed under the plan provisions. Will continue for life. I found another email from April, from the CFO Michael Torres, responding to my question about whether the private equity acquisition would affect retiree pensions. Tom, I want to assure you that vested pension benefits are fully protected under ERISA regulations. The company cannot reduce benefits that have already been earned. Your retirement benefit has been calculated and will be paid according to plan provisions in effect at your retirement date. Cannot reduce benefits that have already been earned. I forwarded both emails to Patricia with a note. Found documentation from before I retired, explicitly confirming my benefit amount and stating it couldn't be reduced. Does this help? She called me within an hour. Tom, these emails are excellent. They show the company explicitly confirmed your benefit amount, confirmed it was guaranteed, and acknowledged that earned benefits can't be reduced. They now try to reduce those benefits. They're contradicting their own prior statements. Can we use these in court? Absolutely. This is exactly the kind of documentation that wins ERISA cases. The company made specific promises about your benefit. You retired relying on those promises, and now they're trying to take them back. That's textbook breach of fiduciary duty. What's our next move? I'm sending another letter, this time attaching these emails and explicitly noting that Meridian's own communications confirm your benefit amount and acknowledge it can't be reduced. I'm giving them one more chance to reverse the reduction before we file. Patricia's second letter went out Monday morning. It was less diplomatic than the first one. Your November 5th response claims Mr. A. Granger's benefit adjustment reflects accurate calculations under amended plan provisions. However, your own communications prior to his retirement explicitly confirmed his benefit amount and stated that earned benefits cannot be reduced. I've attached 2 such communications for your reference. These emails demonstrate that Meridian confirmed Mr. Granger's benefit at $6,215 monthly, described it as guaranteed, and acknowledged that ERISA protects earned benefits from reduction. Any attempt to reduce his benefit now contradicts your own prior statements and violates ERISA's anti-cutback rules. We are prepared to file a lawsuit if this matter is not resolved immediately. The response came back Wednesday, this time not from Robert Hutchins but from someone higher up, Jennifer Park, Meridian's chief legal officer. Ms. Moreno, I've reviewed your correspondence and the attached emails regarding Mr. Granger's pension benefit. We are conducting an internal review of the plan amendments and their application to retirees. While this review is ongoing, we will maintain Mr. Granger's current benefit level. We will contact you once our review is complete. Patricia forwarded it to me. This is good. They blinked. They're not reversing the reduction yet, but they're backing off and forcing it while they review. Translation. Their lawyers told them they're going to lose if this goes to court. How long will this review take? As long as they think they can delay. But we're not waiting. I'm filing the lawsuit anyway. Once they're facing actual litigation, the review will conclude much faster. 2 weeks later, Patricia filed the lawsuit in federal court. Meridian Financial Services, alleging ERISA violations, breach of fiduciary duty, and benefits denial. The complaint included all my retirement documents, the letters from Meridian cutting my pension, And most importantly, the emails confirming my benefit and acknowledging it couldn't be reduced. The filing got attention quickly, not just from Meridian's lawyers but from other retirees who'd received similar letters about pension reductions. Within a week of the lawsuit being filed, I got calls from 3 other Meridian retirees. They'd all received letters cutting their pensions by various amounts, 35% to 45% reductions, with the same vague justification about plan amendments and updated calculations. One caller, Dorothy Williams, had worked at Meridian for 28 years and retired 2 years before me. "Tom, they're cutting my pension by 42%. I'm 73 years old. I can't afford this. But I thought I had to accept it because they're a big company and I'm just one person. Dorothy, they can't legally do this. You earned your pension. They can't take it back." But the letter said the board approved it. The board can't approve something that violates federal law. ERISA protects pension benefits. I've got a lawyer who specializes in this. Let me give you her number. Over the next month, Patricia was contacted by 12 Meridian retirees, all facing pension cuts. Some cuts were larger than mine, some smaller. But the pattern was clear. Meridian was systematically reducing pension benefits for anyone who'd retired in the past 5 years. "This isn't just your case anymore," Patricia told me. "This is a class action. Meridian is violating ERISA on a broad scale, presumably to reduce their pension obligations and improve their balance sheet. We need to amend the lawsuit to include all affected retirees." How many people are we talking about? Based on the calls I've received and some research into Meridian's pension plan, probably 60 to 80 retirees who've received reduction letters. Why would they do this? They're a financial services company. They have to know this is illegal. 2 possibilities. First, they're betting most retirees won't fight back because they don't know their rights or can't afford lawyers. Retirees don't have union representation or HR departments backing them up. They're isolated and vulnerable. Second, even if some retirees sue, the company might calculate that settling a few cases is cheaper than paying full benefits to everyone. So it's a calculated risk? It's a calculated gamble that elderly retirees won't have the knowledge, resources, or energy to fight. They're wrong about you, but they might be right about others. We amended the lawsuit to a class action, representing all Meridian retirees who'd received reduction notices. Patricia sent notice to everyone we could identify, giving them the option to join the case. 43 retirees joined, ages ranging from 65 to 81. Combined, Meridian was cutting approximately $1.30 million annually from their pension benefits. The company's response to the class action was to fight hard. They hired a major law firm, filed motions to dismiss, argued that the plan amendments were properly executed and didn't violate ERISA, claimed that actuarial reviews had shown the original calculations were errors that needed to be corrected. But they couldn't get around the emails. Patricia hammered on this in every filing. Meridian confirmed Mr. Granger's benefit amount in writing, acknowledged it was guaranteed, stated it couldn't be reduced. You can't violate your own explicit promises to retirees. 6 months into the litigation, during the discovery phase, we got access to internal Meridian documents that explained exactly what was happening. The private equity firm that acquired Meridian had commissioned a financial analysis showing that reducing retiree pension benefits by an average of 35% would save approximately $1.80 million annually and improve the company's valuation by oddly $20 million for resale purposes. The analysis included specific recommendations. Target retirees who left in the past 5 years, as they're less likely to have organized advocacy. Use actuarial review and plan amendments as justification. Expect 10-15% to challenge legally. Budget for settlements with challengers at 50-60% of disputed amount. Net savings even with settlements, approximately $1.20 million annually. They'd planned this. They'd calculated that most retirees wouldn't fight and that settling with the ones who did would still save money. Patricia showed me the document. Tom, this is smoking gun evidence. They deliberately targeted vulnerable retirees, knowing it was illegal, betting most wouldn't have the resources to fight back. This isn't a mistake or a good faith plan amendment. This is calculated theft. Can we use this at trial? We won't need to go to trial. I'm sending this to Meridian's counsel right now with a settlement demand. They're going to settle immediately because if this document becomes public in a trial, the reputational damage alone will cost them tens of millions in lost business. Patricia's settlement demand was straightforward. Restore all reduced benefits retroactively. Pay all affected retirees the amounts they should have received since the reduction. Cover all legal fees for the class. And implement oversight to prevent future benefit reductions. Meridian's lawyers called within 2 days to negotiate. The settlement took 3 weeks to finalize, but the terms were clear: all pension reductions reversed. All affected retirees would receive their proper benefit amounts going forward. Retroactive payments for the period when benefits were reduced. $250,000 in legal fees covered. And a requirement that an independent fiduciary review any future plan amendments affecting retiree benefits. Total cost to Meridian, approximately $2.80 million in retroactive payments and legal fees, plus the ongoing cost of paying proper benefits. The $20 million valuation improvement they'd hoped to gain by cutting pensions? Gone, replaced by legal costs, settlement payments, and reputational damage. 3 months after the settlement, I received a check for $14,376, 6 months of retroactive pension payments at the proper level. My monthly pension was restored to $6,215. But more importantly, 43 other retirees received similar restorations. Dorothy Williams, the 73-year-old woman who'd called me, got her full pension back. People who'd been facing financial crisis from the cuts were made whole. A year after I received the original reduction letter, I got a call from Patricia. "Tom, I wanted you to know something. The settlement we reached in your case has had ripple effects. 2 other companies have reversed planned pension reductions after their lawyers pointed to our case. And the Department of Labor has opened investigations into several companies for similar reduction schemes. So other people are being protected? Yes. Because you fought back. If you'd accepted the reduction quietly like Meridian expected, they'd still be doing this. The other retirees in the class action might not have known to fight. The companies planning similar reductions would have proceeded. I just wanted my pension back. You got your pension back? And you protected hundreds of other retirees in the process. 2 years after the settlement, I was invited to speak at a retirement planning conference. This session was titled Protecting Your Pension Rights: What Retirees Need to Know. 2 years ago, I told the audience of soon-to-be retirees my former employer tried to cut my pension by 38%. They sent a letter saying plan amendments required benefit adjustments. They used bureaucratic language to disguise what they were actually doing, taking back benefits I'd earned over 32 years. If I'd accepted it, I had no choice because they're a big company with lawyers. I'd have lost almost $30,000 a year. But I kept documentation. Emails confirming my benefit amount. Communication saying earned benefits couldn't be reduced. That documentation saved my pension and the pensions of 43 other retirees. Here's what I learned. Companies bet that retirees won't fight back. We're retired. We're not part of the workforce anymore. We don't have unions or HR departments protecting us. We're isolated and vulnerable. Companies know this, and some exploit it. But we have more power than we realize. First, ERISA protects pension benefits that have already been earned. Companies can't take them back, no matter what they claim about plan amendments. Second, documentation matters. Keep your retirement paperwork. Keep emails about your benefits. Keep anything that confirms what you were promised. Third, don't accept illegal benefit reductions quietly. If something seems wrong, it probably is. Get legal help. 43 retirees joined my case. Most of them thought they had to accept the cuts because the company said so. They didn't realize they had rights. They didn't know that what the company was doing was illegal. If just one person in this room is facing a similar situation, remember, you don't have to accept it. The law protects you, but only if you enforce it. After the presentation, an older woman approached me. "Mr. Granger, my husband retired from a manufacturing company 3 years ago. Last month they sent a letter cutting his pension by 30%. We thought we had to accept it because they said it was a board-approved plan amendment. Can they really do that? No. If your husband's benefit was calculated when he retired based on his years of service and final salary, they can't reduce it after the fact. That violates ERISA's anti-cutback rules. We're living on his pension and Social Security. A 30% cut would be devastating. Do you have documentation from when he retired? Anything showing what his benefit was supposed to be? I think so. I sent him papers about the pension calculation. Keep those papers. Find a lawyer who handles ERISA cases. Most work on contingency for pension disputes, so you won't need money up front. Show them the reduction letter and the original benefit documents. They'll be able to tell you if you have a case. Won't that be expensive? Fighting might cost legal fees, but they'll likely be covered if you win. Not fighting will definitely cost you hundreds of thousands of dollars in lost pension benefits over your lifetime. Which is more expensive? She nodded slowly. Thank you. I didn't know we had options. That's what companies count on. They count on retirees not knowing their rights and not having the energy to fight. Prove them wrong. 3 years after my case settled, I read that Meridian Financial Services had been sold again, this time at a significant loss compared to what the private equity firm had paid for it. The article mentioned legal settlements and reputational damage related to pension benefit disputes as factors in the reduced valuation. The scheme to save $1.80 million annually by cutting retiree pensions had cost them far more than that in legal fees, settlements, and lost business. The $20 million valuation improvement they'd hoped for had turned into roughly a $40 million valuation decrease. Turns out stealing from retirees is bad for business. 5 years after I received that first reduction letter, I got an email from Susan Chen, the HR benefits director who'd sent me the original email confirming my pension benefit. She'd left Meridian 2 years after my retirement. Tom, I wanted to reach out and tell you something. When the private equity firm pushed management to reduce retiree pensions, several of us in HR raised concerns about the legality. We were told that legal had reviewed it and that plan amendments allowed adjustments. I should have pushed back harder. I should have refused to send those reduction letters. Instead, I went along with it, and it took retirees like you fighting back to stop what we should have prevented. I'm sorry. I wrote back, Susan, I appreciate the apology. What happened wasn't your fault. You were following orders from leadership who'd made the decision. But for what it's worth, your email confirming my benefit and stating it was guaranteed was crucial evidence in the case. So thank you for being clear and specific in that communication. It helped protect not just me, but 43 other retirees. She replied, I'm glad the documentation helped. And for what it's worth, I'm much more careful now about what I put in writing regarding employee benefits. Yeah? Yee. I'm making promises. I make sure they're promises we can keep. If you've stayed with me through this entire story, I want you to understand something. This isn't just about pension law or ERISA regulations. It's about companies thinking they can take back what they've promised if you're no longer in a position to fight back. When Meridian sent that letter cutting my pension, they were betting I wouldn't know my rights, wouldn't keep documentation, wouldn't have the resources to hire a lawyer, and wouldn't have the energy to fight a corporation for years. They were wrong on all counts. Because I'd kept every email. Because I'd documented every promise. Because I was willing to fight for what I'd earned. Over 32 years. And because of that, 43 other retirees got their benefits back too. The emails saved me. The specific, documented promises that the company made and then tried to break. Without that documentation, it would have been my word against theirs. With it, they had no defense. If you're approaching retirement or already retired, keep everything. Every benefits statement, every calculation sheet, every email about what you're owed. You might never need it. But if someone tries to take away what you've earned, that documentation will be the difference between getting justice and accepting theft. If this resonates with you, hit that like button and subscribe. Share your experiences in the comments about pension disputes or times documentation saved you. Those stories help others understand why keeping records matters. Remember, they tried to cut my pension by 38% hoping I wouldn't know my rights or wouldn't fight back. I kept every email. Every promise they made. Every calculation they confirmed. When we got to court, they had no defense. The emails saved me.